Hello, welcome to another episode of the Lifetime Legacy Lawyer Podcast. I am your co-host, Thomas Vick, joined by the other co-host of this program, Seth Wilson. Seth, how are you today?
Thomas, I'm doing wonderful. It was really good to catch up with you off air a little bit and just see how life is going. We're in the middle of fall break season here in northern India or northern central Indiana, and so it's always good to have that time. It shifts the calendar a little bit in terms of what's going on and allows you to kind of catch up a little bit on things as well. So missed recording, but glad to be kind of back in the schedule here. How about yourself?
Yeah, things are going well. We're starting to turn the corner now that we're in the holiday season, really, which is often a busy stretch in my practice, and I'm sure it is for you. You got family stuff to think about, but also lots of clients that are trying to get things done between now and the end of the year. So I'm looking forward to that home stretch here. You know, Halloween, Thanksgiving, Christmas. It's always it's a wonderful time to be in practice in Central Indiana. So
yeah,
we've got.
It's fun to see.
Go ahead.
I was going to say, it's always fun to see the leaves changing color here, and it's just a beautiful time of year as we transition from season to season.
It really is. The colors are just striking right now in Greenwood. I was driving a little bit this afternoon and just really enjoyed the drive. So lots to be thankful for.
For sure. Well, as we think about those kind of things, trips and fall break and holiday travel and things that are coming up, one thing kind of jumped off one of your most recent blog posts was the importance of advanced healthcare directives. And the example used was a case that was pretty familiar to many of us as lawyers in terms of studying this in law school, but highlights that drastic change that can happen in the blink of an eye after a car accident or something like that. And so I thought it'd be good just to remind everyone what is an advanced directive, why is it important to have that set up, and kind of what does that look like as part of your estate plan?
The best way to explain why it matters is an example. A lot of times we talk about the law and we're just expounding on principles, but there's an example that is given in the blog about a woman named Nancy Cruzan, and I'm just going to read from the blog to kind of describe to the listeners what happened to this lady. Nancy Cruzan was a young woman whose life took a tragic turn after a car accident left her in a persistent vegetative state. She could not communicate or make decisions. However, her body was kept alive through a feeding tube. Her parents, believing that Nancy would not want to live in such a condition, fought to have her feeding tube removed. However, they faced legal battles because there were no written instructions from Nancy about her wishes. In 1990, Nancy's case reached the U.S. Supreme Court, which ruled that without clear, written evidence of her wishes, the state had the right to continue life-sustaining treatment. Not until a lower Missouri probate court reheard evidence from new witnesses did a judge grant permission for the hospital to remove the feeding tubes, keeping Nancy alive. She passed away 11 days later. So this is a tragic example about really somebody's life being prolonged when that individual would not have chosen her life to be prolonged in such a manner. And, you can kind of understand the government's perspective. They kind of have a presumption of keeping her alive, but then her friends and family thought, this isn't what she wanted. There's no way that she would want to be connected to these tubes for, an indefinite period of time. And so they're weighing the benefits of the government and of the individual, and where a living will comes into play and where an advanced directive comes into play is somebody can actually exercise, and institute your wishes. in a given situation. And so that's why lawyers talk so much about having your healthcare documents in place, because you want to avoid a tragic circumstance like Nancy Cruzan's.
Yeah, and again, just a horrific example, but highlights the importance of the discussion, because you never know from day to day what might happen. This was a car accident situation, and most of us travel by car every day, multiple times a day in some instances. And so, just again, highlights the importance of having thought through and actually following through on getting a document in place that names what you would want to have happen in that kind of event, along with who's going to be responsible for making those determinations. And many times in my consults with folks, that's a big part of the discussion, because the importance of that type of discussion and decision is it's a weighty matter where you're making a determination as to continued support for this individual's life or not. And having left instructions that are clear and unequivocal are so much easier to follow, because now you can look at what my desires might have been if you're the one making that decision in the midst of the actual event that's happening.
Yeah. Yeah. And one of the questions that is asked in the blog post is, what if you don't have an advance directive? And what that means is the state law is going to determine who gets to make those decisions. And I don't have the priority list quite memorized, but if you're married, your spouse is the first one. And then after that, it might be your parents. After that, it might be siblings. Children are in there somewhere, depending upon their age. And so you could have somebody that is, has a priority over making your decisions for you, but that person may not actually be the one that you would prefer to make decisions for you. So if you don't have an advance directive, you don't actually get to say for sure who is going to be able to make those healthcare decisions for you.
And you don't know or haven't directed what decision you want to be made.
Right.
You're leaving that discussion up to a decision maker. And again, I think that just coupling that back with the burden of that decision, especially for a child maybe who is by statutory default rule placed into that position without any clear direction about what mom or dad might have wanted, is a very challenging situation for that child. And obviously these are very small statistical situations that would ever occur. But again, it's one of those peace of mind type things that we can do with a little bit of advanced forethought and planning, with very relatively limited effort in terms of kind of making those decisions and getting the documents put together. So what, Thomas, are those documents that you would need to address these issues?
Yeah, so number one, having a healthcare proxy. In Indiana, we call that an advance directive, where you name a healthcare representative. So a healthcare advance directive and a living will and a HIPAA authorization. So advance directive, like I said, that's naming somebody to be your healthcare representative to make healthcare decisions for you when you're not able to do so. The living will is a document that states your preference as to end-of-life decisions. And the one that you name to be your healthcare representative will be the one that institutes the wishes that you have stated in your living will. And so those are two documents that you need. And then a HIPAA authorization is there kind of as a separate document so that individuals have access to your medical information if need be. And that's particularly important when you need to be able to make critical healthcare decisions for people. So those are the documents that I think everybody needs when it comes to healthcare.
Yeah, and one thing I will recommend to clients a lot of times on the HIPAA release is go ahead and name anyone that you want to have access to the information at that time. including obviously the decision makers. But there have been occasions where individuals are not listed as an authorized medical record recipient, and they get escorted out of a room at a time where that discussion is taking place, and they're not able to at least hear what's going on firsthand. They may get it from the family members later, but you can help eliminate that scenario by listing them as an authorized recipient of the medical information, but not designating them as someone who has that decision-making authority.
Yeah, that's a good idea. So those are the documents, and of course, as you're in this process, you need to talk to your loved ones about what your wishes are so that they understand it. Yes, there are words on the page that state your preferences as to end-of-life decisions, but having that face-to-face conversation with a loved one about your decision is certainly a huge recommendation to be made there. So talk with loved ones, and then review your documents on a regular basis and update them accordingly. It might be that 10 years ago you did some healthcare documents, but times have changed, people's situations have changed, and so you need to have your documents reviewed on a fairly regular basis.
Yeah, and that's especially important if you have younger children, and then as they potentially age into decision-making positions, because it may have been some time since you last reviewed your plan, and now you have a child that is 18, 19, 20 years old who could help facilitate that decision-making, but your documents still treat them as they're 8, 9, 10 years old and haven't been reviewed since then. So it's always a good idea to review those, every couple of years. Probably no more than 5 years would be the big recommendation there, but just kind of check in and see how things are going.
Yeah. Yep. Well, any other things that we want to talk about when it comes to healthcare documents?
Well, I tell you, the part of the discussion that I least enjoy when we're talking about estate planning is the living will. That document is tough because you're thinking about a very hard situation in life and what you want to do in there. And so I try to get through that piece of the puzzle as quickly as we can, but making those discussions, because that's not something we want to think about. But have that thought once, work through the exercise, and be done with it, at least for that period of time, I think would be my recommendation there. And so you can focus on the things that are important, which is living your life and being with your family and accomplishing what you're meant to accomplish here.
Yeah. My experience is that clients will sign documents very, very quickly when they are about financial decisions. For instance, a trust, a will, a financial power of attorney. But when it comes to that living will and it asks your preference as to end-of-life decisions, that's when it gets real. And they always pause and they say, I need to read this. And, we pause right there and we have to have a discussion. We always discuss what each selection means when it comes to receiving nutrition and hydration, not receiving artificially supplied nutrition and hydration, or deferring to your healthcare representative. And that just highlights to me how personal a decision that is. We're not talking about their money, we're talking about their life. And that, it's an important task that we have to discuss those matters with clients. And you're right. You want to be able to make those decisions and then put them away and kind of breathe that sigh of relief, that we got it done and now we can move on to bigger and better things, and certainly more enjoyable things.
Yeah. And the good thing is most folks won't ever experience this kind of scenario. And that's a good thing. I think as lawyers, sometimes we are around it more frequently than others may be. And so it hits a little bit closer to home in those scenarios. And we carry, I think, the importance of that call to help folks kind of work through that decision on a day-to-day basis, where most folks, they're doing this once every few years or maybe twice in their life at an outside where they're working on their estate plan. And so I think that's why it's a little more impactful potentially to me as an attorney, because I see it day in and day out. And so I just try to make sure that we handle that appropriately with the deference that needs to be there. Like you mentioned, walking through the decisions that need to be made, and how do you counsel and advise through that in terms of the options that are available to make those choices. And so that's an important thing. And like I say, it's just one we don't want to spend a ton of time talking about, but it is so important and so vital to a fully formed estate plan.
Yeah. Yeah. Well, that'll bring to conclusion this episode of the Lifetime Legacy Lawyer Podcast. If anybody wants to get in touch with me, the best way to do so is by going to vicklaw.org and select book a call, vicklaw.org and select book a call. You can get in touch with me online or schedule a phone consultation. Either way is great through the website. And Seth, what is the best way of getting in touch with you?
We are located up here in the heart of Hamilton County, and our city is Noblesville. So we have the web address, noblesvilleattorney.com. So that's the best way to find our contact information and get in touch with us.
Yep. So if you are on the north side of Indianapolis, go see Seth. If you're on the south side of Indianapolis, come see me in Greenwood. Well, that does it for another episode. We'll talk to everybody next time. Thanks, Seth.
Thanks, Thomas.